Act was entirely his work, and without discriminating on the religion, caste, social status of a person, he made this Evidence Act applicable to all the Indians. And beside, Indian Evidence Act, he has done a remarkable work in various legislation also, like Indian Contract Act also. And he has also, worked on the judicial system of British India, where if you want to study about the detailed study on the British judicial system in India, then you can see his work, and you can go Google it, and you will find his work there. So he was a renowned jurist, judge, and lawyer, which has made a good contribution in drafting the legislations in India. So can we have a next question? Yes, the next question is, as per the preamble of Indian Evidence Act, the purpose of the act is to provide, define and amend the law of evidence, to provide, consolidate the law of evidence, to define and amend the law of evidence, to consolidate, define and amend the law of evidence. Yes, the time is up now. So the correct option for this question is option B, that is to consolidate, define and amend the law of evidence. So if we see the preamble of the Indian Evidence Act is not a lengthy one. It just say that whereas it is expedient to consolidate, define and amend the law of evidence, it is hereby enacted as follows, and we have the sections of Indian Evidence. Now, let us move to the next question, that is question number 3. The law of evidence consists of which one of the following? Ordinary rule of reasoning, legal rule of evidence, rule of logic, or all of the above? Yes, the time is up for this question. So the correct option for this question is option number B, that is legal rule of evidence. So when we talk about legal rule of evidence, so it revolves around two things, that is oral evidence and documentary evidence. So, and all the statements which are being administrable in the law, in the court, that those are the oral evidence, and all the documents which can be produced before the law as evidence, that are called documentary evidence. And all the Evidence Act revolves around the legal concept of the evidence. Yes, can we have the next question? That is question number 4. So question number 4 says that which one of the following sections of Indian Evidence Act provide that evidence may be given of the fact in issue and the relevant fact? Section 3, Section 4, Section 5, or Section 6?
Okay, participant, few more seconds. And time's up. So the correct option to this question is option number C, that is section 5. So here's the explanation. That section 5, evidence may be given to the facts which are relevant, and evidence may be given in any suit or proceeding of the existing or non-existence of every fact in issue, and of every such other facts that are relevant, hereinafter declared to be relevant, and no others. Uh, Explanation is there that this section shall not enable any person to give evidence of a fact which he is entitled to prove by any provision of the law for the timing and force relating to civil procedure. So I hope it is clear to everybody. We are moving to another question, and that is question number 5. Um, Question is in front of you, participants, and I'm just starting the time. You have 45 seconds to answer.
I'm sorry. I am visible.
Yes.
I'm
Yeah, we were on question number 5.
yes. Sorry, I had a power cut at my place, so I have to log in with my mobile. So I'm sorry.
And yeah, we have few more seconds for this question, and time's up. Yes, Arpana, you can explain the answer. So the correct option is okay.
Can you? Yeah. So the correct option is option number A. So when we talk about section 14, so this question was illustration of a plane that is like that. 1 second. So here this says that section 14 talks about facts showing existence of state of mind or of body or bodily feeling. So it says that whenever there is any fact which shows that there was an intention of a person, or there was a state of mind for that person to to do some act that is a negligent act or reckless act or ill will act or a good will act, so those facts are relevant. So when we talk about question number 5, so here the illustration O is exactly taken as a question. So we can find these questions also. So we have to take the illustration into consideration also. So here illustration O says A tries for the murder of B by intentionally shooting him dead. The fact that A on other occasions shot at B is relevant as showing the intention to shoot B. The fact that A was in the habit of shooting at person with intention to murder them is irrelevant, because he has already shooted that person B in previous occasions. So it was we can say that there was an intention of A to shoot B. Can we have next question, Anu? Yes, question number 6. Question number 6 talks about fact facts which form part of some transactions are relevant under which sections of Indian Evidence Act? Section 5, 6, 7 or 8?
Arpana, are you like keeping a track of time?
Yes, I'm keeping it.
Okay.
Okay, the times is up for this question. So the correct option over here is option number B, that is section 6. Now section 6 talks about relevancy of fact forming part of same transaction. So it says that if there are two events and which form the part of same transaction, then that facts are relevant for that particular case, irrespective of that that particular event has happened on the same time or some other place or some other time. So let us read section 6. So section 6 over here says that facts which though not in issue are so connected with the fact in issue as to form part of same transaction are relevant, whether they occurred at the same time and place or at a different time and place. Can we have next question, Anu? Yeah. Question number 7. Which of the following is not correct? So we have to mention that which of the following is not correct. So some facts are relevant but not administrable. Admissible. Some facts are admissible but not relevant. All admissible facts are relevant. All admissible facts are not relevant. Okay, the time is up for this question. Anu, can we have the correct option? So correct option over here is option number D. I'm sorry, by mistake it is written C over here. So the correct option over here is option number D. So the correct option is D over here, that D is the correct option that we have to mention which is not correct. So all admissible facts are not relevant. But C says that all admissible facts are relevant. Yes, that is a correct statement, that all relevant facts are not administrable. They may be ruled out due to prejudice or precocity of time, confusion, but all admissible facts are relevant, which relevancy is based on logic. Administrability only rely on the lawful persistence, that is whether a fact can be permitted in court on the basis of the act. Can we have the next question? Question number 8 says that things said or done by the conspire in relevance to the common design is relevant under section 12, 6, 10 or 11. Yes, the time is up for this question. So the correct option, Anu, can we get the next slide, the correct option? Option number C is the correct option, that is section 10. So what does section 10 says over here is, things said or done by conspire in relevance to common design. So if there is any, is evidence we have that any two persons or more than that person has conspired for a particular thing, then any evidence, any transaction between them or anything is relevant for that particular to show that a person a particular intention, that they two people had the common intention. So let us read section 10. What does it say? Anu, can we get to section 10 first? Yes. Section 10 says, where there is reasonable ground to believe that two or more persons has conspired together to commit an offense of an actionable wrong, anything said, done, or written by any one of such person in relevance to their common intention after the time when such common intention after the time when such intention was first entertained by any one of them, is a relevant fact as against each of the person believed to be so conspiring, as well of the purpose of providing the existence of the conspiracy, as for the purpose of showing that any such person was a part of it. That is said by section 10. Can we have next question? Question number 9. Question number 9 says, the case of Sanbul Das versus State of Bihar is related to plea of 𝘂𝑵, rule of res geste, rule of estoppel, rule of res judicata. Anu, are you there? I guess Anu has lost the connection. She was sharing the screen. Please wait a while. She'll join again. So for question number 9, the correct option was option B. One second. There is a connectivity problem. So please, we are very sorry. Please wait for a while. Let Anu connect and we will share the screen.
Yeah, hi Arpana. I'm here. Can you hear me?
Yes, please unmute me because I got muted. Yeah. So I guess you lost your connection. Anu, can you hear me?
Is my screen visible?
Yes, your screen is visible, Anu.
Okay, so we were on question number. I need to show the correct answer.
Yes. So option number B is the correct option for question number 9. So res geste is a Latin word which means things done. This is the rule for law of evidence, as is an exception to hearsay rule of evidence, that hearsay evidence is not administrable. It is a spontaneous declaration made by a person immediately after an event and before the mind has an opportunity to conjure a false story. So this is related to section 6 of Indian Evidence Act. Can we have the next question? That is question number 10. Anu? Anu, can we have question number 10? The connection. So let me share 1 minute. I cannot share the screen as I am not the host. So I am just reading out the next question with for you guys. That is question number 10. Wait for a while. Case name in this question number 9 was 𝗔𝗪𝘅𝗃 versus state of Bihar. So question number
Arpana, there is some issue at my part, but still I'm trying to share my screen. And a serious apologies to each and everyone.
no issues, Anu.
Okay. Can you hear me? We have again question number 9, I guess.
I'm sorry, I guess it is a typing mistake. It is question number. We can say that it is a question number 9A because next question is question number 10. So if we change the question number, so it will be chaos in the next slides. So we can say this question number 9A. So in the Indian Evidence Act, previous conviction of a person is relevant under which of the following section? Section 14, exception number 2nd, section 14, exception 1, section 15, and called question section 16. Okay, the time is up for this question. So the correct option for this question is option number A, that is section 14, exception 2. So what does it say? That we have already discussed section 14 in our previous slide. So let us discuss exception 1 and exception 2 over here. Exception 1 says that a fact relevant as showing the existence of the relevant state of mind must show that the state of mind exists not generally but in the relevance to the particular matter in question. Whereas explanation 2 talks about but where upon the trial of a person accused of an offense, the previous commission of the offense of an of by the accused of an offense is relevant within the meaning of this section. The previous conviction of such person shall also be relevant fact. So as we seen in the illustration that A has this, A has already shooted B in previous occasion. So in that illustration also, if we say and we use explanation 2 over here, and we have seen that he has been convicted, or he has been accused for previously shooting B, then here that previous actions of his is relevant for section 14. Can we have question number 10? So question number 10 says an admission can be in which of the following forms? Electronic, written, oral, or all of the above? I guess this is a very easy question to answer. So I guess all the participants can answer this question.
Also, participants, a small request, kindly answer your questions in a chat box only, if it's possible for you.
Yes. Okay, the time is up for this question. So the correct option over here is option number D. That is it, that an admission can be given in electronic form or in written form or in oral form. So next question, that is question number 11, says all admissions are confession, but all the confessions are not admission. The statement is correct. The statement is incorrect. The statement is partly correct and partly incorrect. All the statements are incorrect. Okay, the time is up for this question now. The correct option for this particular question is option number B. Can we have the answer slide, Anu? So option number B is that this statement is incorrect, that all admissions are confession, but all confessions are not admissions. So it says that every confession is an admission, but every admission in a criminal case is not a confession. So we can understand this particular question by section 21. We're going to discuss section 21 in our next question, in our coming questions. So next question is question number 12. The question in that admission are proved against the maker. Which of the following provisions of the Indian Evidence Act provide for exceptions to the above rule? Section 21, section 22, section 23, or section 20? Okay, so the time is up for this question. Can we have the correct option? So the correct option for question number 12 is option number A. So if we go through section 21, so section 21 says that proof of admission against a person making them and by or on their behalf. So it says that admissions are relevant and may be proof against the person who makes them or his representative in interest, but they cannot be proved by or on the behalf of the person who makes them or by his representative in the interest, except the following cases. So we have these two exceptions, that an admission may be proved or on the behalf of a person making it when it is of such a nature that if the person is uh, making it were dead, it would be relevant as between persons under section 32. And the second exception is that an admission may be proved by or on behalf of a person making it when it consists of the statement of the existence of any state of mind or body relevant in the use made at or or about the time when such state of mind or body uh, exist, existed, and in accompanied by the conduct regarding the falsehood embodied. So these are the two exceptions, and we have the third exception also. And third exception said that admission may be proved by or on behalf of that person making it, if it is relevant otherwise than as an admission. So we have these three admissions for exceptions for section 21. So let us look into question number 13. That is, the word confusion appear for the first time in section number 24, 25, or 26, or 27. Okay, the time is up for this question. So the correct option is option number 20, A, that is section 24. So section 24 says that confession caused by instrument the threat or promise when irrelevant in criminal proceedings. So the first time the word confession came under section 24. So can we have question number 14? A statement by the accused must amount to a confession for the application of section 24, 25, 26, or 27.
Participants, we are on question number 14. So kindly mention the correct question number.
Okay, the time is up. So the correct option here is option number B, that is section 25. So can we have the next question? That is question number 15. Okay. So question number 15 says, A says to B that he has finished his wife forever. Under the Indian Evidence Act, the statements amount to admission, confession, both A and B, none of the above. Okay, the time is up for question number 15. So the correct option is option number B, that is confession. So the confession first time came in section 24, as we have already seen our previous question. But this word confession is not defined in Indian Evidence Act. So if we want to see the meaning of the confession, we have to see the Sir Stephen's Digest on Indian Evidence Act, and where he has defined the word confession, and he says that confession is an admission made at any time by a person changed with a charged with a crime, stating or suggesting the inference that is the commission of that crime. So if we look into the question that A has said that I finished my wife forever, so it amount to confession. Now question number 16. Anu, you have to share the we have to uh, tell the participants
Yes.
about the
Yes.
workshop. So
Yeah, I was just waiting for it. Okay, participants. So yes, there was some issue regarding the net, but no issues. Let's take a 5 minutes break, and let me just quickly tell you that we at LawSikho has came up with a new workshop regarding the judiciary this time. So in that particular workshop, so as we are already telling you about the workshop, so I'll tell you the timelines. Those who are not aware of it, let me just quickly share my screen. Okay, so this is regarding the judiciary workshop, and from today itself we have 10 days left. So whosoever wants to enroll for this particular workshop, I hope my screen is visible, Arpana. Okay, so these are the timelines which you need to remember in your mind, that our first exclusive workshop regarding the judiciary will be held on December 14, and the timing would be 6 p.m. to 9 p.m. And for this, we have kept a prerequisite that for this workshop you need to register yourself, and we have kept a very minimal amount of 200. So basically, this workshop is for all those students who are preparing for judicial services, and those who want to give the edge to their preparation and some different directions, those who are trying so hard but they're not able to crack it, and some need some other guidance. So this workshop will be helpful for them. And in the end, at the bottom of the page, we have discussed certain agendas that these are the certain questions which generally comes in the mind of every judiciary preparation aspirants. So here you can see the questions which we will see, like these are the questions which we will be answering, and this is just a brief, but in the workshop itself you will find a plethora of certain content, and that will be very helpful for you all. And also regarding with this workshop, there are certain other perks and opportunities that have also been attached. So I hope that whosoever will be interested will definitely enroll for this, and we have this amazing faculty who will be guiding you throughout the workshop. Mr. 𝗧𝗫𝗫, who himself has qualified qualified the judicial services of Rajasthan and other law related examination. Mrs. 𝗍𝗫𝗫𝗃, she is our project lead manager for test prep course, and Mr. 𝗷𝘂𝘀𝘀𝗀, co-founder and CEO of LawSikho. So this is it, and many of our participants are aware of this, and these are the timelines which you need to remember. So this was it, and okay. So I hope everybody is clear with this. I'll quickly share the link of today's LawSikho workshop and a chat WhatsApp group where you can get connected, and there you will see that we provide you certain updates regarding our workshop and other law activities related to workshop. So I'll quickly share that link with you, but let's get back to a live mock practice. One second. Um, I hope my screen is visible to everyone. And we
yes,
were in question number 15.
yes, Anu, yours. So we were on question number 16. So let us start with our question. A dying declaration to be admissible under Indian Evidence Act must be made before magistrate, police officer, doctor or private person, magistrate, police officer or doctor or private person. Okay, so the time is up for this question. So the answer to this question is option number D. That is, it can be from magistrate, police officer, or doctor or private person. So it says that a dying declaration is recorded by the magistrate, then it will hold an evidentiary value than any other dying declaration. But if the magistrate is not present, then doctor or police officer or private person can record the dying declaration of that person. Now, question number 17. In which of the following case the Supreme Court of India said it is not an absolute rule of law that dying declaration must be corroborated by other evidence before it can be acted upon? 𝗷𝘂𝗱𝗶𝗪𝗏 versus State of Maharashtra, Pakal Swami versus King Emperor, Kushal Rao versus State of Bombay, or Harjit Kaur versus State of Punjab. Okay, so time is up for this question. So the correct option over here is option number C. That is Kushal Rao versus State of Bombay. So here Supreme Court said that court has to satisfy itself that the dying declaration made by a person is not made under any undue influence, or he was his at correct state of mind, and if the court is satisfied that the dying declaration was not made under any influence or in this correct state of not in a correct state of mind, then the conviction can be upheld, and that then dying declaration can be that it is a final statement and it can be upheld by the court. Now can we have the next question? Question number 18. So question number 18 say under section 32 subclause 4 of Indian Evidence Act, the declaration as the public right and customs are admissible as a private right, and customs are admissible both A1 and 2, and only as the custom are admissible. Okay, time is up. Can we have the correct option over here? So the correct option is option number A, that is as a public right as a custom of admissible. So here section number 32 says that cases in which statement of relevant fact by a person who is dead or cannot be found. So it says that the statement written or verbal of relevant fact made by the person who is dead or who cannot be found, or he is not incapable of giving evidence, or he cannot appear, then it cannot be prosecuted without an amount of delay or expenses which under the circumstances of the case appears to the court unreasonable, are themselves relevant fact in the following cases, and we have this 8 list, and section point 4 says that or giving opinion as a public right or custom or matters of general interest. Now, can we have next question? Question number 19. ASUB for rupees 1000 and shows entries in his account book showing B to be in depth to him to his amount. The entry is not relevant. Relevant does not have the evidentiary value or inadmissible. Okay, so the time is up for this question. So the correct option for this particular question is option number B. That is, it is relevant. So when we talk about section 34, section 34 talks about entries in books of account when relevant. So it says that entries in the book of account, which are generally maintained in the course of business, then such entries are relevant as an evidence in the court. And this question was taken from the illustration of section 34 itself, whereas it says that ASUB for rupees 1000 and shows entries in his account book showing B to be in depth to him to his amount, to this amount. This entry are relevant but are not sufficient without other evidence to prove the depth. Can we have next question? Question number 20. Question number 20 say, which one of the following section of Indian Evidence Act has been substituted for the old section by IT Act 2000? Section 39, section 22, section 47 or 65? Okay, the time is up for this question. So the correct option is option number A, that is section 39. So section 39 says what evidence to be given when the statement forms part of the part of a convention, document, electronic record, books or series of letter or paper. Can we have next question? Question number 21. Which of the following judgments is relevant under section 43 of the Indian Evidence Act? Judgment of an insolvency court, judgment of a matrimonial court, judgment of a probate court, or judgment of criminal court? Okay, so the time is up for this question. So the correct option is option number D, that is the judgment of criminal court. So if we see section number 43, so section 43 says judgment etc other than those mentioned under section 40 to 42 when relevant. So judgments, order or decree other than those mentioned in section 40, 41, 42 are irrelevant unless the existence of such judgments, order or decree is a fact in issue or is relevant under some other provisions of this act. Now, can we have the next question? That is section 22. Sorry, question number 22. Question number 22 says, which of the following sections deal with the proving of fraud or collusion in obtaining judgments or incompetency of the court? Section 42, 43, or 44, or none of the above? Okay, the time is up. So the correct option for this question is option number C, that is section 44. So section 44 talks about fraud or collusion in obtaining judgment or incompetency of court may be proved. So let us move to the next question, as we the time is already up for the webinar. A person is called an expert who has special skill in foreign law or science of art, has particular knowledge of the subject, has experience, or all of the above. Okay, so the time is up for this question. So the correct option for this particular question is option number D, that is all of the above. So section 45 talks about opinion of expert, where it says when the court has to form an opinion upon a point of foreign law or of science or art, or as the identity of handwriting or figure impression, the opinions upon the point of a person uh, specially skilled in such foreign law, science, or art, or in question as the identity of hands or figure impression are relevant fact, and such person is called an expert. So all of the above is the correct option. Now next question, question number 24. The question is whether a certain document was written by A. In this case, which of the following is or are relevant? Another document is produced with is written by A. The opinion of expert on the question whether two documents are written by A. The opinion of expert on the question whether two documents are written by a different person, or both 1 and 2. Okay, so the time is up for this question. So the correct option for this particular question is option number D, that is one, both A and B. This question is also taken from the illustration of section 45, and the illustration is illustration C. So here it says the question is whether a certain document was written by A, another document is produced which is proved or admitted to have been written by A. The opinion of expert on this question, whether the two documents were written by the same person or by different persons, are relevant. Now, this is the last question, that is question number 25, which says that which of the following statement is correct? In civil cases, the character to prove the conduct imputed to the party is not relevant. The criminal proceedings in criminal proceeding, bad character of the accused is not relevant unless the evidence of good character has been given. The criminal proceedings, the previous convictions of accused is relevant as an evidence of bad character, or all of the above. Okay, the time is up for this question. So the correct option for this is option number D, that all the statements A, B, and C are correct. So this was all about the quiz on Indian Evidence Act. So thank you all, and thank you for participating. And I guess many of you has given the correct option. And I guess now Anu will going to declare the result. So meanwhile she declare the result, I shall talk about the workshop which we are having at LawSikho on 14 December. So it is exactly 10 days from the event, and many of you has already applied for it, you have registered for it. And see, why it is important for registration here is that because here you will get the insight of the judiciary. So if you get the everything, you will going to understand what are the main subjects you have to focus on, what kind of material you are required to study for judiciary, what are the common mistakes you make for when you prepare for judiciary, why you need an external help while preparing for judiciary, why um, while many people try to study on their own. So what things you have to follow while not getting any external effect, uh, or uh, and many other questions, and not related to judiciary, also for other competitive exam for law graduate also. You, if you are thinking to give another different examinations not related to judiciary, for you, for example, you are going for a CP, or you're going for a JLO or something other examination, so here also that this workshop will help you to how to go about preparing for such competitive examination. So if you have any question, you can just ask me. I guess one person has asked me something. I just, one second. I cannot see the chat box. Anu, can you please share me the chat box?
Yes, Sumedha, we have one question from Sumedha Kalsi, and the
Yes.
participant is asking that request to strike off. And it is related to question number 9, case of Sanwal Das, as the question was not visible, and by the time it was showed, the answer was shown, as there was connectivity issue. Okay. Also,
Yes.
yes, participants, I haven't marked the question number 9, but the another question number 9A. So I got the answer for that question only. तो मैंने जो 9A के आपने आंसर्स किए थे वो ही किए, क्योंकि मेरा नेट कनेक्टिविटी इशू हुआ था. सो मैंने जो फर्स्ट 9 वाला क्वेश्चन था वो मेरा भी स्किप हुआ है. सो मेरे को आंसर वैसे भी रिसीव नहीं हुए थे किसी के, बट जिन्होंने 9A का आंसर किया है, दैट आई हैव टेकन एंड दैट आई हैव कंसिडर्ड इन माय मार्क शीट्स. आई होप दैट इज क्लियर विद यू ऑल, क्योंकि मेरे पास वैसे भी आंसर्स नहीं थे. सो या.
Yeah. Thank you, Anu. So yes, question number 9 was related to Sambal Das versus state of Bihar, and it was related to rule of res geste, which is related to sections section 6 of Indian Evidence Act. Ma'am, 20 I answered within minute, but I delivered late. Okay, Priya, that will be on discretion of Anu. I guess she will going to take your this particular thing in the option that you have given the answer on time, but it was delivered late. Can you explain MCQ number 15? MCQ number 15. Let me see what does it have to say. So yes, A says to B that he has finished his wife forever. Under the Indian Evidence Act, the statement amount to confession. So how this particular statement amount to confession? Because the word confessions appear for the first time in section 24, as we have already discussed that. And this particular section does not define the word confession. So if you want to understand what confession exactly means, so confession is an admission made at any time by a person charged with a crime, stating or suggesting the inference that he has committed the crime. So here A has said to be that he has finished his wife forever. So here that particular statement of A amount to confession. So any other question you have related to Indian Evidence Act or the workshop or judiciary or any other competitive exam, you may ask here. Okay, I guess there is no other questions from the participants. So yeah. So I was talking about the workshop. So workshop is providing all such answers to you. Secondly, workshop is also providing the all the relevant material, how to study, the exact path to study for judiciary, and how many states you have to cover, you can give how and how to prepare for different states, and why a person should appear for what different states while going for this. What is the career of law in SEBI? So there is a judicial office, sorry, in SEBI you have an examination that will be happening in January. So its registration, I guess it is already closed. So there is a law officer vacancy in SEBI. So you have to give the paper, and on that basis you have been selected. And there are two different type of papers, paper 1 and paper 2. So if we have a landing page of SEBI, you can go there, and you will have all the insights of SEBI and what are the career opportunities for SEBI also. So you have many, if you do not want to go for judiciary, there are many other competitive exams also. For example, UGC NET is also there for your if you want to go for assistant professor, if you want to make your career in academics, so you can go for UGC NET. We have a course for that also. So different careers opportunities we have as a law graduate. If you have not able to clear your judiciary, or you do not want to do judiciary but you want to go into a government job, then there are different papers. For example, JLO is also there, so you can go for JLO. So you basically all the examination have the similar syllabus, only pattern of questions are different. So here the approach, how to approach these different papers, you have to go through, you would need a guide, a way or a guide to give you that particular insight of that particular paper. But the course is similar, so it is not difficult to, if you're preparing for judiciary, you can also have a backup for other competitive exams too. So I guess, Anu, is the result finalized?
Yes. Okay. One second. Yes, I have results with me. So yes, so thank you participants for joining today's live mock. So I have taken the 3 positions today, and 3 positions I have taken. So जो third position पे है today, we have Vandana Modanwal. So congratulations, Vandana. I am repeating again because there were 2 participants with the same name, and there is just 1 number difference in the position. So fourth position पे we have Vandana Chaudhary, but जो third position पे है, she is Vandana Modanwal. So congratulations, Vandana. Second position पे today we have with us Vartika Tiwari and Pushpinder Kaur. So congratulations both of you. And today at first position we have 3 participants. So that's commendable. जो first position पे है, we have 3 names. Sumedha Kalsi, Kajal, and Neha Gandhi. So I hope I'm clear with the winners name today. So congratulations everyone. And please provide your feedback to us that how was the session today, except that that internet got haywire because that was that happens. But I hope the session was good, and the questions were also relatively moderate, and some were, having a higher relevancy, and they were also from the past year papers. So I hope everybody liked the session today. And yes, we will keep arranging such sessions, and there are certain other live mocks that are arranged in the series of our live mocks. So please share your feedback with us. And this was it. And I hope Arpana has cleared all the queries from our participants today. Arpana, are you there?
Yes, Anu, I am.
Okay, so I guess we have taken all the relevant questions from our participants today.
Yes, we have taken all the relevant questions.
Okay. Okay. So thank you participants for joining, and thank you Arpana for conducting such a wonderful quiz. And I hope today's question will be helpful in the examination of judiciary. So thank you participants, and thank you Arpana. And now I'll sign off. And thank you participants for such a wonderful feedback. And we'll keep conducting the live mock sessions. Thank you everyone. Now I'll sign off. Webinar Executive Anu Bhatnagar.
Thank you, Anu. Bye.